This presentation is on antitrust policy and regulation. A trust is a group of sellers who cooperate rather than compete. They cooperate by agreeing to set prices, limit output, and otherwise avoid mutually destructive price warfare. Price warfare is bad for the firm, but good for the consumer. Another name for such a group of sellers would be cartel. Whether you call them a trust or a cartel, their objective is to cheat the public and the rest of the business community in order to maximize their own profits and wealth, by acting like a monopolist. Just after the Civil War, America began to industrialize with significant economic changes, such as the emergence of the railroad, mass production, the use of interchangeable parts and mechanization. America, still being a primarily agriculture-based economy, had little experience with the tactics that businesses could use to gain advantage over consumers. The economy needed some way to prevent the concentration of power into the hands of a few large enterprises and the elimination of competition to the disadvantage of smaller enterprises and, of course, to the consumer. The Sherman Antitrust Act of 1890 was the first major piece of legislation designed to outlaw strategies by firms that would intentionally result in the concentration of an industry into the hands of a few sellers. The Sherman Antitrust Act was divided into two sections. Section 1 outlaws every contract, combination, trust, or conspiracy that restrains trade. Section 2 restricts people from monopolizing or attempting to monopolize. The strategy doesn't even have to be successful, it is the conscious attempt to monopolize that was made illegal. The Sherman Act gave the Department of Justice the task of seeking out violators and prosecuting them in court. In the beginning, the Sherman Act wasn't very effective. In fact, most of the violations were prosecuted against labor unions which, according to the courts, were illegal trusts. The first major application of the Sherman Act to businesses was the Standard Oil case of 1911. John D. Rockefeller, the founder of Standard Oil, was able to control 90% of the petroleum industry in the United States. He did this through predatory pricing strategies, driving firms out of business through cutthroat pricing and buying up their land and equipment at bargain basement prices. He was also able to buy firms through mergers and acquisitions of other, smaller oil companies. The Supreme Court found that Standard Oil had about 90% of the petroleum market. Although this was not a pure monopoly, it was close enough to be considered a violation of the Act. The 1911 Standard Oil case was a landmark case in antitrust law because, by judicial precedent, it established what is known as the rule of reason. Judicial precedent is effectively a law based on the findings by a judge. It is used by other courts as a basis for ruling on situations that are not covered by the actual law written and passed in Congress. Congress can't possibly write a law that would cover every possible contingency because many of them are unforeseen. In its findings, the Supreme Court ruled that largeness and market dominance is not, per se, illegal. We must use reasonableness, hence, the term, rule of reason, in ruling against a firm, just because it dominates a market or an industry. The term per se is Latin for by itself. According to the Supreme Court, largeness and industry dominance could conceivably be due to superior management decisions, more aggressive technological innovations, or just good luck. Market dominance, based on these factors, is legal and legitimate, according to the rule of reason. On the other hand, a behavior that would indicate a conscious attempt to become a monopoly is, in and of itself, illegal, per se. Today, courts still use the rule of reason and the per se rule in deciding on antitrust cases. Section 1 of the Sherman Act is known as the per se rule. Attempts to monopolize or restrain trade is, per se, illegal. No excuses. Section 2 is the rule of reason. If a firm dominates or controls most of the industry, that is not necessarily illegitimate or illegal. The court will judge on the reasonableness of how the firm obtained that dominance. If it was by being a more productive firm that served customers better, that's okay. If it was by strategies that would make the firm dominant, that's not okay. Standard Oil was ultimately found guilty of a Section 1 violation of the Sherman Act, and broken up into 34 different companies. Its attempt to gain dominance and monopolize the petroleum industry was ruled as illegal, per se. Today, many of those Standard Oil companies still exist: Standard Oil Ohio, Standard Oil California, Standard Oil New York, Standard Oil New Jersey, and others. In 1926, Standard Oil New Jersey adopted the trade name SO, which is phonic for the Standard Oil acronym SO. Eventually, it became Exxon, and today, having merged with the Mobil Oil Company, is known as ExxonMobil. The U.S. Steel case of 1920 was another landmark decision for the Sherman Antitrust Act. The Department of Justice accused U.S. Steel of being a monopoly because of its significant dominance of the steel industry. However, this case confirmed that size and dominance is not, per se, a violation of the Sherman Act. U.S. Steel obtained its dominance of the steel market by being more productive and efficient than the other companies. It was found not guilty of any violation based upon the rule of reason. There was an interesting case in 1945 involving Alcoa, the Aluminum Corporation of America. Alcoa, having obtained 90% of the aluminum market, but had not violated any antitrust laws, nor had it made any conscious attempt to monopolize, was accused by the Department of Justice of violating the Sherman Act. It competed with other aluminum firms for government contracts during World War II, and was awarded many of them because of the quality of their product, the speed of their delivery, and their pricing. Despite that, the Supreme Court, ignoring the rule of reason, ruled that Alcoa's dominance was in violation of the Sherman Act. Since then, however, the courts have applied the rule of reason. From the beginning, due to the general and unspecific way in which the Sherman Act was written, the business community demanded a more explicit explanation of what was legal and what was illegal. The result was the Clayton Act of 1914. This act strengthened and made more explicit the Sherman Act of 1890. The first provision of the Clayton Act was to outlaw price discrimination. Price discrimination means charging different prices to different customers for reasons other than differing costs. Firms used this to charge the highest amount for a product that an individual was willing to pay. In some cases, different prices were charged to people of a different age, race, or sex. Today, it is perfectly legal to offer discounts on some goods and services to children, students, and seniors. The Clayton Act also outlawed tying contracts. A tying contract is an agreement in which the seller conditions the sale of one product, the tying product, on the buyer's agreement to purchase a separate product, the tied product, from the same seller in a different market. The reasoning is based on the fact that the consumer is harmed when forced to buy an unneeded good, known as the tied good, just to earn the right to purchase a desired good, the tying good. The Clayton Act also prohibits acquisition of stocks of competing firms when it would result in less competition. One firm could buy up a competitor's stock and make decisions that would lessen competition. Finally, the Clayton Act prohibits interlocking directorates. An interlocking directorate exists when one person sits on the board of directors of two competing firms. What could possibly go wrong there? Also, in 1914, the Federal Trade Commission Act was passed. This act established the Federal Trade Commission to identify and prosecute violators of antitrust legislation, along with the Department of Justice. Here are a couple of other significant pieces of antitrust legislation. The Wheeler-Lee Act of 1938 specifically defines the power of the Federal Trade Commission. It also outlaws unfair and deceptive sales practices, such as false advertising. The Seller-Keefe Offer Act of 1950 prohibits anti-competitive mergers. There are three basic types of mergers. Horizontal mergers are mergers among firms in the same industry. This is the type of merger that is most likely to be considered a violation of the Seller-Keefe Offer Act. Vertical mergers are mergers among firms where one is a supplier of resources to the other firm. These mergers are very likely to be considered a violation of the Seller-Keefe Offer Act because competing firms might find it difficult to buy resources. Finally, conglomerate mergers. These are mergers among firms in unrelated industries. These mergers are the least likely to be considered anti-competitive. Here are some examples of landmark cases in the history of antitrust legislation. We've already mentioned the Standard Oil case of 1911, the U.S. Steel case of 1920 and the Alcoa case of 1945. We've referenced the DuPont cellophane case of 1956 in a previous video on elasticity. DuPont controlled 100% of cellophane production, and were therefore charged by the Department of Justice of being a monopoly. The lawyers for DuPont argued that there was no such thing as a cellophane industry. Instead, the market should be defined as the flexible container industry, of which DuPont only had about 33% of sales, not enough to be considered a monopoly, or even dominant. The concept of cross-price elasticity was used to show that consumers considered other products, such as wax paper, tin foil and other products as close substitutes, and therefore cellophane should be considered a part of that industry. The Supreme Court found in favor of DuPont. In 1998, Microsoft Corporation was accused of eliminating competition by bundling Windows Explorer with the Windows operating system. A lower court found them guilty of a violation of the Sherman Act's per se rule, and ordered that Microsoft be broken up into two companies: Microsoft, a software development company, and Windows, an internet browser company. However, the Supreme Court overturned the decision. Rather than the structural remedy, breaking up the company, the Supreme Court decided on a behavioral remedy. Microsoft could not retaliate against any company that produces software that competes with Microsoft Windows or Internet Explorer. This was the first instance of a court finding a behavioral remedy in an antitrust case. A behavioral remedy is, essentially, a promise by a firm to behave itself.